Good morning, good afternoon, good evening. Welcome, everybody. Thank you for joining us to the second in our speaker series hosted by the Columbia Center for Sustainable Investment, CCSI. We hope everybody's doing well, everybody's safe and healthy. At CCSI, one of our goals is to be presenting cutting edge issues on investment arbitration, on sustainable investment, on human rights. That's our philosophy. We try to get diverse voices. And today promises to be a very special episode. We have a fantastic speaker, member of parliament, Miss Heidi Hautala, speaking on a very important topic, the EU approach to responsible business conduct, ongoing development on mandatory human rights and environmental due diligence. So, very exciting topic. We're really looking forward to this. My colleague who you see on the screen, Jesse Coleman, part of CCSI, is going to talk a little bit about CCSI and will then have the honors to introduce our speaker. But I will be remiss if I don't acknowledge on behalf of Arnold and Porter our deep gratitude and thanks to our speaker. Jesse, I'm going to pass the floor to you to introduce CCSI and our speaker. Take it away, Jesse.
Thank you so much, Kabir, and welcome everyone to the second of our three-part speaker series. For those who are not familiar with CCSI, we are a joint applied research center of Columbia Law School and the Earth Institute. Our team is dedicated to developing and advancing policies and practices that shape investment so that it contributes to and does not undermine sustainable development. We are really privileged to be able to convene discussions like this speaker series in collaboration with Kabir and our series sponsors, Arnold and Porter. And I am really honored to now introduce our speaker for today. Heidi Hautala is a Finnish member of the European Parliament representing the Greens and Vice President of the EP. She also serves on several parliamentary committees, including the Committee on International Trade and Subcommittee on Human Rights. Of particular note, given our topic of discussion, MEP Hautala established and serves as chair of a cross-party working group on responsible business conduct at the EP. And this working group has advanced many of the developments around mandatory due diligence that we hope to learn more about today. We're really eager for participants to share questions with us, so please do post these in the Q&A box and we'll turn to as many of these questions as we can following MEP Hautala's remarks. So I will now try to successfully share my screen before turning it over to MEP Hautala for these remarks.
Yeah, thanks you, Jesse. It's really exciting to have this transatlantic comparison of notes on responsible business conduct. So I'm very happy to share with you what is at the moment going on in the EU and in the European Parliament on responsible business conduct. But what I can say is that the EU thinks and says that it is in a leading role in the interrelation between business and human rights, recognizing the UN guiding principles as the authoritative policy framework. But it took quite a long time to progress to the actual implementation of the UN guiding principles. And I think if everything that is now on the table in the EU will be realized, we will be a global leader, and because the EU is still the biggest internal market in the world, I think 18% or so, I think this market will attract many players, and we will be able to show the way also beyond the EU borders because of the attraction of the internal market. And now is the time really to regulate that market towards responsible business conduct. And I would first like to take you a little bit through what the steps have been until now on anything resembling due diligence. And we can go to the first page. Yes, indeed. So where indeed is the EU coming from? And I'd like to share with you that there are 2 or 3 instruments which follow the principles of mandatory due diligence. First, there's something that, to my mind, resembles the US Lacey Act on trying to stop imports of illegal sourced timber to the country, to the EU member states in this case. By the way, we can already jump to the next page. But thanks for finding the presentation. Yeah, so the timber regulation aims to reduce illegal logging by ensuring that no illegal timber or timber products can be sold in the EU. It was created as part of the EU's FLEGT action plan. FLEGT is Forest Law Enforcement Governance Trade. And this has been enforced in 2013. So this regulation, it prohibits operators in Europe from placing illegally harvested timber and products derived from illegal timber on the EU market. Legal timber is defined as timber produced in compliance with the laws of the country where it is harvested. We have another important binding mandatory instrument, and that is the EU Conflict Minerals Regulation. It actually will be enforced on the 1st of January 2021. So this regulation would require EU companies in the supply chain to ensure that they import minerals and metals from responsible and conflict-free sources only. We call this regulation 3TG because the scope is tin, tungsten, tantalum, and gold. So 3 metals plus gold. And so the EU importers should meet international responsible sourcing standards as set by OECD. And this instrument should ensure that global and EU smelters and refiners of 3TG source responsibly, that they help break the link between conflict and illegal exploitation of minerals, and that they help to put an end to the exploitation and abuse of local communities, including mine workers, and that it will support local development. And I should mention that as the OECD guidelines are voluntary and recommendation, then it took some time to convince the EU that, and especially the member states and the Commission, that we should turn this immediately into a mandatory instrument, because we already had the OECD voluntary guidelines, and this was a bit of a struggle to get through, but the end result was that, for instance, conferences of bishops and development organizations, many different civil society players, they actually appealed to the EU to turn this immediately into a mandatory instrument so that really it would make a change on the ground. So, by the way, sometimes we now also talk about conflict timber, because illegal timber is also related to conflict, as you know. But then I would like to turn to a turning point, and I will speak about the EU Sustainable Finance Action Plan. Maybe it wasn't quite realized how important it was when it was adopted in 2018, so quite recently actually. The Sustainable Finance Action Plan is now in a kind of an implementation phase, and I'd like to refer back to its Action 10 of 2018, which says that fostering sustainable corporate governance and attenuating short-termism in capital markets, the Commission stated that it will assess the possible need to require corporate boards to develop and disclose a sustainability strategy, including appropriate due diligence throughout the supply chain and measurable sustainability targets. So this actually caused a lot of work towards due diligence. I am aware that also the EU Fundamental Rights Agency started to look into how the Pillar 3 of the UN Guiding Principles could be applied, namely the right of the access to justice of corporate victims. And this is an ongoing work within the EU still. So as you know, because you probably are professionally advanced, and your knowledge of the EU is above the average. So I don't need to tell you that the European Parliament is one legislative arm of the EU, and the Council, which is now the 27 member states, so excluding the UK, obviously, is the other legislative arm. And the European Commission is a bit like an executive that makes the proposals to the two legislative arms. So the Council presidencies also played a role. And the first one who really took very seriously the responsible business conduct was the Dutch presidency in 2016. They follow one another in 6-month sequences. But nothing much happened after that. And last autumn was a very busy time for responsible business conduct when the Finnish Council presidency took office. And they had published a paper a year ago called Perspectives Paper on Business and Human Rights Toward a Common Agenda for Action. By the way, I'll send all the links to you so you can look into this afterwards. And it was a special honor for everyone because a conference that the Finnish Council presidency organized in Brussels in December, exactly a year ago, was also attended by Professor Ruggie, who made a really important speech and encouraged the EU to undertake what we have coined in responsible business conduct, a proper mix of a smart mix of mandatory and voluntary measures towards responsible business conduct. So can I have the next page, please? Yes. So in fact, there was an unexpected push to responsible business conduct with the COVID-19 crisis. One wouldn't really believe that because obviously, let's say the business as usual scenario would be that the companies should not be burdened with new administrative measures and laws. And but what happened indeed was that the EU took even more rapid steps towards mandatory human rights due diligence. And one reason was that what has now been realized in many countries is that the COVID-19 has brought a special vulnerability of supply chains. And that's why the discussion now is about diversifying or shortening supply chains. But also we realized, for instance, that there were special cases where workers in third countries were literally risking their lives to provide protective gear to Europeans and Americans as well. Talking about medical and rubber gloves, personal protective equipment, manufacturers were accused of subjecting migrant workers to forced labor and withholding wages. And eventually, it's very interesting that the US Customs and Border Protection, CBP, has enforced a detention order on subsidiaries of the world's largest medical glove maker, Top Glove Corporation, which is an action that has been intended to halt importation of goods from companies suspected of using forced labor. And in the EU, we do not have any similar mechanism, but in the European Parliament's International Trade Committee, the discussion is actually quite strong at the moment about the need to put in place an EU instrument on prohibiting the imports of goods from companies which are suspected of using forced labor. And I'd also like to mention that we observed that the same CBP has enforced a detention on Xinjiang cotton because of this well-documented, I would say, genocide of the Uyghur population. And it's interesting to know that actually some estimate is that 1/5 of all cotton consumed and produced in the world has some trace of the Xinjiang cotton when it's mixed with other sources. So indeed, the COVID-19 has been a factor in our work towards due diligence legislation in an unexpected way. And for instance, the European Parliament, when it's adopted a non-binding resolution on 17th of April in the middle of the first wave, the Parliament stated that it is convinced that corporate human rights and environmental due diligence are necessary conditions in order to prevent and mitigate future crises and ensure sustainable value chains. And also the OECD has sent a very clear message saying that the responses to the COVID-19 crisis need a responsible business conduct approach. Taking an RBC approach, says the OECD, and using risk-based due diligence to identify and address adverse impacts would bring short and long-term benefits. In particular, the OECD concluded it would enhance companies' capacity to build and increase resilience to better deal with current and future supply chain disruptions and enhance their ability to access private and public finance. So can I turn to my next picture, please? Thank you. So now I'd like to explain how, in fact, what the concrete developments have been. And last spring, it was very clear that we are on our way towards an EU due diligence legislation. The EU Commission had published already earlier a study on due diligence requirements through the supply chain. And I'm very happy again to share with you that the link to that publication. It's some hundreds of pages, it's very thorough. But it was a very, it was a small victory in itself that the Commission had decided to do such a study, but this turned into a bigger victory when Justice Commissioner Reinders, who's also responsible for company law, explained that voluntary action to address human rights violations, corporate climate and environmental harm, although incentivized through reporting, has not brought about the necessary behavioral change. And out of the options, the EU Commission has a regulatory and legislative intervention clearly singled out to be the most effective. So I'd just like to mention a few key observations in that extensive study, a survey of a large number of businesses. 70% of business survey respondents agreed that EU-level rules on a general due diligence requirement may provide benefits for business. Second, those supportive of EU rules believe it would create legal certainty and a single harmonized standard in place of different and varying approaches in the member states. And you have seen many of them in the past years, starting from the UK Modern Anti-Slavery Act, and now the latest one we see sort of on the edge of the EU in Switzerland. There was a referendum about the quite stringent due diligence law, which was turned down. But I'm sure it will get consequences, because even the Swiss multinationals say that they want to see how to put this in place at the EU level. Because indeed companies have indicated in the study that the EU Commission commissioned that it would help leveling the playing field and increase leverage on supply chains in third countries. So indeed, the level playing field is something that has been repeated by not only companies and governments, but also by the civil society that very much supports the introduction of EU-level mandatory measures. In the study, the companies also saw the benefit of due diligence as a defense should a dispute arise. Very interesting. Stakeholders favored a mandatory due diligence as a legal standard of care and generally preferred a cross-sectoral regulatory measure, as many companies operate in multiple sectors. So last summer, the European Commission published another related study on directors' duties and sustainable corporate governance. This study complements the due diligence study, and it suggests that a possible future EU action in the area of company law and corporate governance should pursue the general objective of fostering more sustainable corporate governance and contributing to more accountability for companies' sustainable value creation. So now we are at the final stage before the actual legislative proposal by the EU Commission. An inception impact assessment and a feedback period for a public consultation is currently ongoing, ending in February 2022. And I would very much support you to look if there would be something for you to say in this consultation to highlight the need of global standards and the transatlantic connection. So in its official annual planning, which is the Commission work program, as we call it, it is already indicated that a legislation on sustainable corporate governance will be proposed to foster long-term sustainable and responsible corporate behavior, and that it will be out in the second quarter of 2021. That's very soon. So the only thing we don't know is how this proposal would exactly look like. But turning to my next slide. Now, I would like to explain to you what is happening meanwhile in the European Parliament and in the Council, which, as I said, consists of the member states. So the EU co-legislators have a very special active role already before the Commission's proposal. And this is, I would say, partly because the Commission's president, Ursula von der Leyen, she has declared that she will take the European Parliament's legislative initiatives much more seriously than her predecessors. So we have a case for the Commission really to look into what the Parliament expresses. And another thing is that the EU Commission, which you will have seen, is very dedicated to what we now call EU Green Deal. So the Green Deal also has an external dimension, and that is why the European Parliament is involved in giving its informal view to the European Commission. And it's only sensible for the Commission to listen to the Parliament, because it can sense what the reception by the other legislative arm of the EU would be to its proposal. So we are discussing endless hours details of a possible corporate due diligence and corporate accountability instrument. And we are also doing this in several parliamentary committees. I'd like to mention that we already have some hints on what the Parliament thinks if we look at a couple of recent adopted documents. So I would mention that the Human Rights Subcommittee has already given its opinion, and it recommends that there will be included a liability regime. The Human Rights Subcommittee recommends that the future legislation include provisions for joint liability of companies for human rights violations and damage to the environment, directly linked to their products, services, or the operations, unless the companies acted with due care and took all reasonable measures that could have prevented the harm. So that's a very clear statement towards legal liability. And I also want to mention that there was an EP resolution towards an EU legal framework to help and reverse EU-driven global deforestation. And I'm sure that you also have been discussing how the global international community could respond to this ongoing disastrous deforestation in various key regions of the world, like the Amazon, Central Africa, and Southeast Asia. So the European Parliament has proposed that the European Commission should present without delay a proposal for an EU legal framework based on due diligence to ensure sustainable and deforestation-free supply chains for products which are placed on the EU market, with a particular focus on tackling the main drivers of imported deforestation. So this has already been adopted by the European Parliament's plenary session. So the second example is a bit more let's say, reliable guidance, because it has been voted by the whole Parliament. Not unanimously at all. There is skepticism towards mandatory human rights and environmental due diligence, but there's also very detailed political debates about how this all should be shaped. So then I would like to turn to what is happening in the EU Council among the member states briefly. And indeed, very recently, on the 1st of December, the employment and social ministers of the 27 They approved Council conclusions in which they call on Member States and the Commission to promote human rights in global supply chains and decent work worldwide. And I am convinced that the actual EU Council presidency has committed itself fully to this aim and has facilitated this statement by the Member States. And indeed, for the first time, the EU Council asked the Commission to launch an EU action plan that is focusing on shaping global supply chains sustainably, promoting human rights, social and environmental due diligence standards and transparency by 2021. And this includes a call for a proposal from the Commission that there will be an EU legal framework on sustainable corporate governance, and that it should include a cross-sector corporate due diligence obligations along global supply chains. So I think this is quite significant because even if the European Commission would come up with a very progressive proposal, and what could happen is that the European Parliament sort of makes it even stronger, then it could happen that the whole exercise gets stuck in the Council representing the Member States. And I can just mention to you that it did happen when the EU Commission proposed measures to improve women's representation in company boards. It's been stuck in the Council for 8 years, and we don't want this to be stuck in the Council for any longer than is necessary to bring it into a legally binding instrument. So we move on with my next slide. So now I'll turn a little bit to the detailed discussions on EU due diligence. How would it look like? First of all, I think there is pretty much agreement that the level playing field is indeed the starting point, and that the instrument should apply to both EU and non-EU based companies operating in the EU internal market. So this is already a relief to many European companies who are afraid that they would suffer from competition from non-EU companies. And by the way, let me just think aloud that it could very well be that if even non-EU based companies would have to fulfill those due diligence requirements, then it might have a kind of a spillover effect to other regions as well. And this is something that could be discussed, of course. So we seem to agree that the instrument, and now I'm talking about the European Parliament, but across party lines. So it should apply to all large companies and selected companies in risk factors, high risk sectors in small and medium-sized enterprises or mid-sized enterprises. So indeed, all large and then risk sector based SMEs. There's a kind of a debate on something that I don't think you can really draw from the UN guiding principles, that some have proposed that a company could produce an absence of risk statement if it comes to the conclusion that it doesn't have any real risks to report and which would trigger a due diligence process. But I would, from my part, I would say that then why not accept that it will do a very light due diligence process. So this is disputed at the moment. We can move on. Yeah, so I'd like to just now to conclude and mention that, of course, this does not happen in a vacuum. And a very interesting, I would say, a pilot project is introduced this autumn, and that is the so-called multi-stakeholder dialogue on sustainable cocoa. And I can tell you that the multinational cocoa and coffee companies like Nestle, Mondelez, Mars, Wrigley, you can blame them for many things, but they actually call for a mandatory human rights and environmental due diligence because they cannot anymore ensure to their customers that the cocoa that they produce from the EU, it's mainly coming from Ghana and Cote d'Ivoire, which is two Western African states, is free of child labor and deforestation. So now what we are seeing is that the company call has been heard by the EU, that companies alone cannot eradicate child labor and deforestation from their supply chains. So they need also sort of, let's say, government participation. And the EU is thinking about a new kind of partnership agreement between itself and on one hand, and the other hand with these two cocoa producing countries, Cote d'Ivoire and Ghana, in order to create enabling conditions to get the kids to school and make sure that cocoa plantations are not extended to protected areas, etc. And then we have very, very lively discussions in all institutions, at least in the Commission and in the Parliament, on responsible business conduct with a view to EU trade policy. And this is, of course, something which I would need to hear from the US side, if there's anything like that in your deliberations. So how to indeed make sure that the EU free trade agreements and their sustainable development chapters include enforceable provisions and even sanctions on breaches of those free trade chapters. And I would say that it's very likely that the EU Commission is coming up with a plan on how to do this, at least to some extent. That would be an important step away from the idea that trade is just trade, because I think, let's face it, trade is not anymore just trade. Then lastly, to mention the EU's role in within the UN Human Rights Council towards a legally binding instrument on transnational corporations, which has been sort of casually called the UN binding treaty. The EU has not been very enthusiastic about this work because, and I share that criticism that somehow it's not very convincing that it would leave some domestic enterprises out of the scrutiny of supply chains, and especially state-owned enterprises, so that state-owned enterprises would enjoy a very special protection from scrutiny of the supply chain. That I think is not something that could be supported. But now I also believe very much that the EU and the European Commission, its member states, are trying to revise its attitude. And a big reason to me is that now that the EU has started a very vigorous work on responsible business conduct in its own jurisdiction, so and its own legislative work, so it gives kind of an obligation also, and maybe a benefit, to bring it to the international arenas. So I think what we will see in the coming, maybe, should I say months, I don't know, is that the EU will have a mandate. So the Commission would need a mandate from the member states to sort of re-engage in this process in a more thorough way. So this is what I wanted to communicate to you. And I think I've only exceeded my speaking time with 5 minutes, so sorry for that. And if you want to look into the website of the informal cross-party working group in the European Parliament, so it's very simple, responsiblebusinessconduct.eu. So thank you very much. I look forward to questions and comments.
Thank you very much. That was fantastic. As you mentioned, the EU is definitely the leader, facilitating our thinking in these areas. So, we keep our fingers optimistically crossed for humanity. We have received a couple of questions and we'd like to present them to you. The first question we have received is from Professor Ko-Young Tang from Harvard Law School. And, he was, key person at the World Bank and at ICSID. And his question is really trying to understand these different regulations that you outlined, Like, he wants to understand the scope of these. Are the provisions mandatory? Are there penalties for violations? Are there investigative powers for enforcement? It's really trying to understand how mandatory the provisions are. So,
yeah. I think my microphone is open. Yes. Yeah. Thank you for that question. And of course, we all recognize the work done in the Harvard Law School, and I don't need to repeat my admiration for Professor Raggi for his groundbreaking work in the UN, and I'm very happy that he's following what we're doing. So yes, the instruments that I mentioned are mandatory. The EU timber regulation and the conflict mineral regulation as well, which, as I said, it will be enforced on the 1st of January, but many companies and groups of companies are already preparing for it. So maybe I need to say something about this. Yes, there is an enforcement mechanism, and take the conflict mineral regulation. It states that there will be a national competent authority who has to monitor the implementation of this regulation in the 27 member states. So just like in the US, there's quite a strong division of powers between between the federal and the national level. And in the conflict mineral regulation, the industry schemes, which sort of ensure that the requirements are implemented, must be accepted by the European Commission. So yes, and in case actually, I'm not in a position to tell you exactly what the penalties and sanctions are, but there will be a strong enforcement. And by the way, can I just mention that a big failure of the UK Anti-Modern Slavery Act is without any teeth. And I've met the first commissioner for anti-modern slavery, Commissioner Kevin Hyland, who resigned, and why at least partly his resignation was due to the fact that he was powerless. You know, the companies could report, they could not report, and there was no competent authority to sort of monitor the enforcement, and no teeth. So. It's really this future due diligence legislation. Everybody agrees that it has to be mandatory, but then the question starts: what kind of liability should there be? And maybe it was a bit of a Freudian mistake from me not to say that this is the biggest dispute. Of course, it's the biggest dispute because. What we now among the members of the European Parliament who work on this almost like half time now. So what we say is that we want to see administrative sanctions, we want to see civil liability, and in the very, very extreme cases, of course, criminal sanctions would apply. But it is not by far sure at the moment how this all will be settled. And one important discussion is that we distinguish between a kind of obligation of means and obligation of result. So if you fail with your due diligence process, which is sort of stipulated in the law, then it doesn't mean that that you would have to obtain a result. You know, you have to follow the process, and then the real tough issue that if harm is caused to in the environment or people, where there is a direct link between the company and the harm, then I would say that it's very likely that the civil liability will be the main instrument, and there we have to rely on the 27 different regimes of civil liability within the EU. Because there is no EU jurisdiction for such things. That we have, of course, the International Conference of Private Civil Law, and maybe there's a case for looking into some instruments on applicable law and jurisdiction. But some people say that it's not the safest way to go, because if these instruments would be reopened, then nobody would really guarantee what would happen. So this is how little I can explain to you about the question of penalties and sanctions.
Thank you very much. Let me pass it to Jessie to ask you the next question. Thank you very much.
Thank you so much, MEP Hautala. That was a really terrific overview of these developments. I wanted to go back, if I could, to the points that you made about EU trade policy and EU trade and investment policy, I guess, and how this interacts with all of these developments around responsible business conduct and due diligence. I know that the RBC group has this shadow action plan around implementation of the UNGPs in the EU, and the plan highlights a number of priority areas, including, of course, around due diligence, but also EU trade and investment policy specifically. It talks about human rights impact assessments, engaging civil society during negotiations, ensuring that there's more transparency in negotiations, but also ensuring that future agreements provide access to remedy to those who are affected by the operations of businesses who receive protections under these agreements. And I'm wondering if you could talk a little bit more about whether these types of objectives remain sort of priorities for the working group, and whether you see room for progress in this space, particularly given the developments around mandatory due diligence that you've been talking about.
Okay, thanks a lot. I think the EU Commission now sees very much that how sustainable development will be incorporated into the EU trade policy also is linked to the due diligence. On Monday there was a debate in the European Parliament's International Trade Committee with the highest official in the EU Commission's Trade Department, and she said that there's many things that can be done to adjust trade agreements to sustainable development, but we should also understand that there are autonomous measures that the EU can put in place, including the due diligence legislation. And I think it will be very helpful for the EU companies if the trade agreements also will contain binding and mandatory articles on sustainable development, because that would then set the scene. But then the companies themselves would find it easier operating in a country which is not exactly known for huge level of protection of the environment or labor rights or governance to sort of apply to what we would proudly call European values, like respect for human rights, etc. So all these are linked, but how far the EU trade agreements will be adjusted is, of course, not something that the EU alone will decide. It's always with a partner. I could give you an example. The EU has ratified a free trade agreement with Vietnam about a year ago. And there's what the Parliament, whose ratification also was needed to put this in place, insisted that there's a roadmap to invite the Vietnamese government to put in place certain ILO conventions against forced labor, against child labor, to allow free bargaining and freedom of association, which is of course a big ask from a communist one-party rule. But we see that this kind of, let's say, also voluntary measures are leading to some progress. So not everything has to be done through sort of mandatory rules. And we are seeing now that Vietnam is trying to create space for independent labor unions, which has not been the case. But let me also mention something that you are very aware of, is that with this introduction of what we call RCEP, the new trade bloc, also incorporating many the Asian countries and Oceanian countries in China. So what we have noticed is that this free trade agreement has nothing at all of sustainable development in this dimension. So how will this impact countries and regions who want to connect trade with sustainability and human rights? That is a big question. But I would again say that, and I'm curious to hear how the US would see this, or you as US citizens. I believe that the European market is big enough to sort of invite the companies to follow the principles of sustainable development, if that will be a requirement to operate in that region. And I think that the due diligence will be extremely helpful in this respect. But we are discussing the principles that should be incorporated into the trade agreements, including more power for the what we call domestic advisory groups, where the parliament is very much insisting that they have to be accessible to the civil society. The EU Commission has actually now launched an independent complaint mechanism for the civil society who feels that the trade agreement is not applied properly.
Thank you very much. We're getting flooded and inundated with questions. So we're going to have to be a little strategic on what we can present. Lots of questions have come on due diligence. Before we get there, just one point. We're all keeping our fingers crossed for January 20th, the US inauguration date. Hopefully then we will get a better idea in the US and sustainability. We had one question that was asked by Doug Castle from King and Spalding. And, he looks at this new UN treaty draft. So we're really looking at the international regime, and the draft there, the ambit covers both domestic companies and state-owned entities, right? The inclusion of the latter is interesting. And he wants to see your reactions, your thoughts. You touched upon this, but this was a brief and a pointed question, so we love your reactions.
Thanks. Yeah, I'm aware that there's been, let's say, from the EU point of view, there's been progress I think there was a 0 draft, then there was the first draft number 1, and are we dealing with the third draft number 2? Or 2? Yes. Yeah, I think it's. I would say to some extent, this could be, and here I have to be humble and modest, of course, but it could be due to the sort of dissatisfaction of some major players like the EU, maybe the US, I don't know, to incorporate in these negotiations. So, and I also think that this is conducive for the re-engagement by the EU in the negotiations, because what I was maybe once or twice in Geneva myself participating in these meetings, which follow every October, and I saw that the EU made some rather, let's say, sour or neutral statements towards this process. And but there has been a progress from the point of view of those who want to see it applied on international, multinational, as well as domestic, including state-owned companies. So I would like to hear maybe some remarks on how you see the situation. And I'm not only giving answers to you, I'm also asking questions, as you can see.
Oh boy. I think it's probably a positive development. I think state-owned entities can sometimes exert huge influences beyond just commercial activities. So I think to that extent, fingers crossed, it's a positive development. Let me pass it back to Jessie so Jessie could ask you the next question. We are flooded with questions, so we will be strategic in how we ask them to you.
We have, as Kabir noted, we have many, many questions. So I'm going to ask a question that I hope gets sort of summarizes a few that we've received. One of the, I think, concerns around mandatory due diligence requirements that some civil society organizations have advanced sort of in the context of developments around national level requirements, but also in the context of discussions around the legally binding instrument, is the risk that these requirements might become sort of a box ticking exercise. And that as I think you referred to this in your remarks, that companies might use them to shield themselves from liability if a dispute arises. So I'm curious whether you have, and I'm sure you do, whether you have thoughts on really key elements that need to be enshrined in mandatory due diligence legislation to ensure that when preventive measures fail, companies are still held liable for harms caused or exacerbated by their operations, and individuals or groups harmed still have access to effective remedy.
Yeah, this I think is really at the core of the exercise. And I'm sure that there are companies and in the corporate world, those who want to see this as a box ticking exercise. But on the other hand, I would say that there's a serious effort going on to make sure that it is not just a box ticking exercise, and that we try to eradicate the ways in which companies could shield them from liability and accountability. So I think I cannot overemphasize what you have just said, that liability, whether it's administrative, civil, or environmental, criminal, or a combination of those, and access to remedy is really key. So I don't think there can be any meaningful mandatory human rights and environmental due diligence without liability. And the discussions there are pretty much in relation to what we have seen in let's say, there are other instruments in other areas, like the protection against sexual harassment and discrimination, that it is clear that we don't have an equality of arms situation in the case of a poor Pakistanis community, which is trying to get the remedy from a European-based multinational company. So we need to have a reversed burden of proof in that situation. So it is the company that must show in front of a court that it has taken all the due care according to the due diligence process, which now we have to write into the law as clearly as we can. So on the box ticking as such, I think the EU has one more instrument that I should mention, which also I think was a bit of a groundbreaking, and that was the Non-Financial Reporting Directive, NFRD we call it. So it is already enforced, and it will be revised. So the transparency part, let's say the disclosure of information will come from those rules. So I should sort of maybe condense a little bit the actual lawmaking exercises. The one is towards a mandatory human rights environmental due diligence. And may I just point out that nobody now excludes environment. So we really include environmental damage into it as well. And then there's the Non-Financial Reporting Directive, which will be even improved for how it is to be put on the same level with the financial report of the company in terms of responsibility. And then well, I only touched briefly the issue of directors' duties. And I have a feeling that that is the most tough one to get through, because then you enter into the holy domain of companies and the company boardroom. What are the responsibilities of company directors? And I think this will be the toughest part of this exercise. But definitely, in one sentence, this should be beyond box ticking.
Forgive me, unmute yourself. Forgot to do the pivotal thing here. Yeah. With your kind indulgence, perhaps we could ask you one final question. We are flooded with questions, and I'm going to do something sneaky. I will combine two questions, both by women. So I think that's amazing. Yulia asks us that, you had spoken about specific obligations in business and human rights, that are being mulled in the European FTAs, the free trade agreements, And her question is there any consideration to have these in investment chapters,
Yeah.
The example she gives us is the Dutch model bit, which had these obligations in their model treaty. And she wants to know if there is any other ideas as such floating around.
Well, maybe you know that that the EU is at best negotiating with China on an investment agreement, and this happens in the middle of the discussion and revelations on the Uyghur labor force. And I mentioned the US how you call it, withhold release orders, WRO. We don't have anything like that, but I'm very curious to see that how the EU will actually reach a final negotiation outcome without any attention to human rights. And I happen to know that they are discussing ILO conventions. So I think this will be a big test for the EU, whether it's really serious about business and human rights. And I cannot promise to you that it will be. But I know that your institute is very active on investment agreements and investment protection, and I think the bigger struggle will be there. As you know, the EU Commission has introduced the negotiations on how do we call it, multilateral investment court, and it has also started to put in place a kind of a revised forms of investment protection agreements. They're called ICS, International Court System, which is a certain improvement with a view to what we had, the traditional ISDS, which I think nobody anymore wants to have, at least the civil society and responsible politicians not. But what we can see is that the international court system is only an improvement in terms of a bit more transparency, a bit more independent guarantees of the judges, you know, but it doesn't give any possibility for counterclaims. And so I would say that, and here I must say that the official EU line is that this is now the standard. And that obviously this is how they are negotiating from the EU side on the multilateral investment court. But the question is that how can we come to a situation where we had at least a possibility for counterclaims to companies? How can we balance the rights and obligations of companies? How can we bring the victims, the civil society on board? And how can we guarantee the right to regulate? So I see this is maybe something that would be interesting to discuss with yourselves again, to hear from you.
Well, we would love to continue that discussion with you and with others who are joining us today. We are just about to reach the top of the hour, so I would like to take a moment to thank MEP Hautala again so much for joining us for this really thought-provoking and engaging discussion. We clearly have a lot of work to do in this field and in the field of investment governance as well. Thanks to Kabir for co-moderating this session, and to Arnold and Porter for sponsoring this series, and to all of you for joining us for this discussion. The next session in the series takes place this Monday, December 7th at the revised time of 11 a.m. New York time. So thank you all so much, and please take care.
Thank you and have a great weekend.